Special Prosecutor Robert Cosgrove has been AWOL, not responding to the mega motion to dismiss all criminal charges against Aidan Keaney, but he's reappeared with some flowery language.
You lost. And you know what you did.
The Commonwealth of Massachusetts, by and through Special Prosecutor Robert Cosgrove, has finally issued its response to the mega motion. I'm attorney Andrew Myers. This is About the Law. With me is California attorney Yoli Medina. Hi, Yoli.
Hi there. How are you?
I'm good. So we did a whole episode on the mega motion when it was filed back in the end of September. And then 2 deadlines passed for the Commonwealth to respond. But I guess, they can do whatever they want. That was my reading of the fact that, Mr. Cosgrove filed his response late on the same day that he filed a motion to allow a late filing.
Yeah. Yeah, he's like assuming that it's going to get granted.
I think that assumption is a pretty good one because, some crazy things happened that we're going to get into in a minute. And I hate to say it, but I'll say it anyhow. He is a retired Superior Court judge. And so the Superior Court judges now are wont to, punish him for being late. And so I don't think anything's going to happen that he filed it late. If you or I did that, might be a little bit different, but for a retired judge to come in and say, all right, I needed more time, I don't think anything's going to happen.
Yeah, probably not.
So here is Special Prosecutor Robert Cosgrove's memorandum in opposition to Attorney Bettero's affidavit in support of motion and associated submission. I guess he's even questioning whether the mega motion was a motion. So I'll just read the first paragraph, then we'll jump into it. Commonwealth's memo in opposition. The defendant has filed a group of documents supporting an unfiled motion or motions, most notably what is effectively a motion for reconsideration of the denial, in large part of the defendant's previously filed and decided McCarthy-Odell motion to dismiss. Now, why does he call it that? Well, he cites 2 cases. The present defense documents include Attorney Mark Bettero's affidavit in support of motion, which was 87 pages, various exhibits, about 55, and a memorandum of law in support of motions to dismiss the indictments. Functionally, it is difficult to distinguish the Bettero affidavit from a memorandum of law, although it also serves the function of informing the court of what unfiled motions it is supporting. Bettero affidavit 1A-C. In brief, the defense seeks 1, outright dismissal of the pending indictments pursuant to Commonwealth versus Odell. And then number 2, dismissal of the indictments for the Commonwealth's alleged failures in providing discovery. And 3, disqualification of Special Prosecutor Kenneth Mello. So that's what the Commonwealth views in the mega motion. I don't know. They're saying that procedurally it was all deficient because an actual motion was not brought. Did you have any thoughts about that?
Well, I mean, the memorandum of law in motion, I guess I can see his point. Technically, there's no notice of motion. It's just a matter of how the paperwork's titled. I don't know. I don't think it makes much of a difference. After setting forth these aims, the Bettero affidavit first lurches into a section entitled Background, which is essentially a hagiographic portrait of the defendant as a crusading, heroic journalist fearlessly pursuing the truth, exposing falsehoods, and I can't read.
The stamp goes over that. Yeah, you can't read that.
Witnesses in the Karen Reed case, laying bare the corruption of local and state, looks like authorities, resisting the attempts of the all forces of evil, aka the Norfolk County District Attorney's Office, to deter him in his courageous and never-ending battle for truth, justice, and the First Amendment.
Now, come on. Now, I was always taught that to be direct, this kind of sarcasm, he must know the judge. I'm just telling you that straight out. I don't care what anybody says. He must know the judge, because this kind of sarcastic language is not generally allowed in court or not approved in court. Or if it's used, you don't go anywhere trying to pretend like, oh, the other guy's Superman. And some of this language, hagiographic. All right, I'll admit it. I had to go to the dictionary and look it up, and here it is, hagiographic. Very admiring of someone and representing the person as perfect or much better than they are. So he's describing the way that the defense is, referring to Mr. Keaney, and it rises to ecclesiastical levels. That's what the dictionary says, is that initially something that was hagiographic talked about a saint or some other person very high up. And so he's really using this sarcasm, and if it was in any other context, I'd say it doesn't work. But here we are in this case in Massachusetts, and he continues, in reading Beddoes' Economiums to Saint Keaney, one is irresistibly reminded of Oscar Wilde's comment on the death of Little Nell, the virtuous child in Charles Dickens's The Old Curiosity Shop. One must have a heart of stone not to laugh. The Commonwealth has had occasion to respond to such drivel in the past. That's really amateurish, I'm sorry. And with some reluctance, now does again. Rather than it reinvent the wheel, it quotes liberally from its responses to the defense previous motions to dismiss. So, again, I am not embarrassed to admit I had to run to the dictionary in reading Beddoes' Economiums. What does that word mean? What it means is warm, glowing praise. Why didn't he just say that? Why didn't he just say in reading Beddoes' defense of Mr. Keaney? Why did he have to say Economiums to Saint Keaney? It's just, I don't know. Am I going too far in characterizing this as amateurish?
No, I don't think you are. I think he's trying to use big words like to make to make the prosecution much higher than what Keaney is. Like to make Keaney look lower than that. Like using big huge words.
Yeah, he's being very derisive. And I skipped over all the part that he says, well, this is what we said in the previous motion. So if that's what you said in the previous motion and you're padding out this one, we're not going to read it.
Right.
So here's the argument.
Okay. On February 14th, 2025, the defendant filed his McCarthy-Odell motion to dismiss indictments for lack of probable cause and for the prosecutor's impairment of the integrity of the grand jury with misrepresentations of fact and law. Henceforth, First MD, docket 69. At the time he did so, the Commonwealth had provided in discovery to the defendant all of the grand jury minutes. Among other things, he thereby necessarily had full and complete knowledge of the following:
that the grand jury heard, or that Special Prosecutor Mello ultimately did not ask the grand jury to return an indictment against Keaney for illegally wiretapping Mr. Scanlon. All of the testimony of all grand jury witnesses, including Detective Lieutenant Tully. And then, an outline of some other things.
And then, writing on Keaney's behalf, Attorney Beddoes has made the same arguments, having adduced various examples of alleged sins committed by Mr. Mello, some the same presented by Attorney Bradel in the first motion to dismiss. He plucks a few different examples, but all of them were readily available in support of the defendant's position in round one. As one justice of this court has aptly put it, a motion is not a dry run or a dress rehearsal to come back once an adverse ruling is obtained to try and do it all over again.
So here he's saying, Attorney Cosgrove is, this is the same old stuff. He's just trying to get a reconsideration of what was already argued in the previous motion. But then he contradicts himself a little bit further on. We'll see it. He contradicts himself and says, well, this is new here, and this was not brought up in the previous motion. So he contradicts this. So remember what Yoli just read. To be sure, a judge may permit a motion that has been heard and denied to be reviewed when substantial justice requires. Emphasis added. Such instances should be rare, however, lest, as said in a different context, judges would become Penelopes, forever engaged in unraveling the webs they wove. Renewal, however, is typically appropriate where new or additional grounds are alleged which could not reasonably have been known when the motion was originally filed. And then he concludes this thought: the defendant's motion for reconsideration flaunts each and every one of the prerequisites for reconsideration, which may explain why he shrinks from honestly labeling it as a motion for reconsideration. Pretty derisive language, if you ask me.
Yeah. In his initial motion, the defendant did not attack, as he now does, any of the video evidence offered by the Commonwealth. For his present motion for reconsideration, he now claims that the prosecutor and Detective Tolley, number one, deceived the grand jury by grouping videos the Commonwealth offered as evidence of intent on a folder on the thumb drive exhibited labeled intent. Number two, showing edited clips that allegedly deprived the grand jury of viewing Keaney's actual full episodes, many well over 2 hours long. And three, assigning titles to the edited clips that did not match the titles Keaney assigned the full episodes.
I don't remember Betterow ever in what's been come to be known as the mega motion. I don't ever remember him saying that they should have run all of the episodes 2-3 hour. That was not his point. The point in the mega motion, if I recall correctly, and correct me down below, the point was what they did is they created these titles which were labeled intent. And I forget how many of them there were. There were quite a few, and they were in a folder titled intent. So now where intent is a element of every criminal charge, including those that were brought against Mr. Keaney, the grand jury could say, oh, hey, look, intent, look at all these episodes. And they retitled those episodes. That was what they were saying in the mega motion. They never said show all of them, show all, I think it comes to about 50 hours. That was never said. So this is a perfect propaganda technique where you exaggerate what the opposition has said, and then it's easy to knock it down. So. Yeah,
it's editing the titles of the video was right. What I remember. Yeah,
exactly. No, you're right.
Now it says, although the Commonwealth will shortly develop. What? Oh, sorry. Let me start over. Sure. Although, as the Commonwealth will shortly develop, these arguments have been entirely waived by their omission from the first MD, which is the first motion to dismiss.
Right.
First stoops to briefly address the substance of Keaney's newly raised claims concerning the videos.
Counsel's use of the term edited to describe the clips is artful in falsely. This whole paragraph is BS. All right, I'll read it and then I'll comment. Counsel's use of the term edited to describe the clips is artful in falsely implying that the contents were somehow modified or distorted. Were that so, one might expect the 88-page affidavit to offer examples of the edits, but there are none, and that is because the edits consist entirely of exact clips of relevant content broadcast by Keaney. The only editing is selection. Well, isn't editing selection? When you edit, you sit down and you select, even if it's only one clip. That is editing. So the appropriate course, according to counsel, would have been to show, and that's, again, this is a propaganda technique where you exaggerate what the opponent says, then it's easy to knock it down. And that's exactly what's being done here. The appropriate course, according to counsel, and this is never what they said, would have been to show the entire episode for each show, or by Mr. Keaney's counsel, over 50 hours of content, prescinding from any question as to whether subjecting the grand jury to such an extended dose of Keaney's video would have violated the constitutional prohibition against cruel and unusual punishment. Come on, again, exaggeration. Such a course would have inserted confusing and irrelevant material, and doubtless would have generated additional defense arguments that Keaney was prejudiced because the Commonwealth presented evidence of other conduct for which it did not specifically request indictment. So I would submit that this is a good example of card stacking. They exaggerate what the other side has said, and then it's easy to knock it down. It's just really easy to knock it down.
Yeah. If one were to seriously entertain the defense's play the whole video argument, a useful way of thinking about it would be by analogy to the doctrine of verbal completeness, which holds that where the Commonwealth places into evidence passages from a defendant's statement that it believes support the charge, the defense may then put in contemporaneous evidence from the same statement which contradict, modify, or otherwise throw light on the prosecution's passages.
Yeah, enough said about that. We now jump down here to an excellent point that, again, card stacking. The grand jury hardly could have been misled by the titles Lieutenant Tully used to identify the excerpts he played for them. Consider the specific examples which the defense singles out as misnamed and misleading episodes. For example, those titled by Tully as "Trying to Destroy Colin Albert's Life." That was not the title. They inserted that in. Life as Normal is Over. Impromptu Live 8/7/23. Albert Should Be Afraid. Better Affidavit. Paragraph 256. All of those titles were taken from Keaney's exact words, which the grand jurors saw and heard him speak as the YouTube clips were played, edited, and which this court had as exhibits as the defendant's previous McCarthy-Odell motion to dismiss. If there was any prejudice to the defendant, Keaney himself was the author of it, damned not by sinister manipulation by the Commonwealth, but of his own words. But again, they went in to the episodes, the prosecutors before the grand jury did. They went into the episodes, they cherry-picked some words, and then they said that was the title, when Mr. Keaney himself had much less, abrasive and sinister titles. And so they're kind of twisting around the whole argument.
Right. And they're saying that the clips that he said that they pointed out are through his own words. So that's why they titled those videos by what he said. But at the same time, it's kind of misrepresenting what the original intent of the video was.
Yeah.
Because he may have said certain things, but the whole, you have to take it into context. But I don't know. It's
and then we get to the whole Catherine Peter being a former employee of Mr. Keaney, and apparently they parted company in really bad terms. And she was, as stated in the mega motion, she was feeding the prosecutors down at the Norfolk County District Attorney's Office, information, because she had such an animus of hatred against Mr. Keaney. And so that's where we go here with the Commonwealth's response, again, just kind of minimizing everything.
Okay, Keaney acknowledged in passing the existence of his prior motion to dismiss, but asserts that he filed it without access to undisclosed evidence, which he claims was important. Federal Affidavit 33. The defense designates two such pieces of evidence. First, communications between Miss Peter, Mr. Mello, and Tully, Federal Affidavit 34, which was critical and, if disclosed promptly, would have been included in support of the defense's first motion to dismiss. And second, the previously discussed presentation to the grand jury of excerpts from Kearney's broadcasts that were labeled by Tully. The defense claims that it learned of this for the first time on September 4th, 2025. As fully demonstrated above, that contention is risable.
And that's again, he's going into his thesaurus and using crazy words. It's just, he should just say that contention is laughable, or this is Cosgrove's attitude. This is his words. That contention is laughable or not important. I don't read that. I read a lot of law. I read a lot of cases. I read a lot of motions. I read a lot of legal material. And this doesn't follow. This is written by someone that is trying to be sarcastic. It is true, however, that since the previous defense motion to dismiss, the defense has acquired communications. Oh, I thought there was nothing new. Remember up in a previous paragraph, he said, this is a motion for reconsideration and there's nothing new. But wait a minute. But there's more. It is true, however, that since the previous defense motion to dismiss, the defense has acquired communications among Special Prosecutor Mello, Lieutenant Tully, and Ms. Peter, and so has quote unquote new evidence. That being undisputed, the remaining legal question for this court is whether the significance of that evidence is such that substantial justice should dictate an undoing of Judge Doolin's previous denial of the defense motion to dismiss. It should not. Okay, there's something new here.
Yeah. There is a factual dispute that the court should resolve. The defendants paint Ms. Peters as a member of the prosecution team, indeed, the dominant player to whom Special Prosecutor Mello outsourced investigative work. Per Betterow, Mello was supposedly aware that she edited Mr. Keaney's content with her own editorial slant and bias and reviewed private links she sent to him 2 days before the grand jury proceedings started. The implication of the latter assertions, apparently, is that Mello and Tully were spoon-fed maliciously edited clips by Peter, which they then mindlessly regurgitated as grand jury exhibits. As Lieutenant Tully's affidavit demonstrates, that is not the case. Ms. Peters was not part of the prosecution team, but was a source of information among many sources.
Are we parsing roles here? I mean, yeah, everybody knows she's not an attorney and she wasn't the prosecutor, but if she was feeding them, inculpatory information and slanting it as she went, she's not a part of the prosecution. She's not a part of the district attorney's office, but I think arguably she is part of the greater team in a global sense.
Well, she's either she's acting as a confidential informant or
right.
or investigator on behalf of the prosecution. I mean, I don't know. It could be a number of things if all of this is true, what she was doing, which I think it is.
Yeah, I mean, she's playing a role in the whole thing. She's feeding him information, which they're then just like spoon feeding to the grand jury. Some of the Commonwealth's problems have been logistical, which are not the defendant's fault, but inform the realities of production. By way of background, the investigation into Keaney began around May or June of 2023. Attorney Mello, a resident of Bristol County, was engaged as special prosecutor around September of 2023. 6 months later, in March of 2024, the Norfolk District Attorney recruited the undersigned to assist Mr. Mello with some legal research, writing, and similar tasks. Mello, however, proved to be gravely ill and has been physically unable to appear in court, requiring the undersigned effectively to assume full responsibility for the case. Okay. In point of fact, the undersigned has never been able to meet with Mr. Mello in person since undersigned counsel's entry of an appearance in any case against Mr. Keaney. While counsel has largely been able to obtain discovery materials directly from the Norfolk District Attorney's office, some of the necessary materials have been in Mr. Mello's possession, and his ongoing health problems and intermittent hospitalization have retarded the process of acquiring them. Well, I wonder if they ever heard of FedEx. Cosgrove Affidavit, paragraph 16. To return to the previously mentioned May 8th discovery letter, the court will note that in addition to the discovery produced by undersigned counsel, it references discovery previously provided by Detective Lieutenant Tully. Given Mello's illness, then hoped to be transitory, Tully was employed in the prosecutor's normal role of providing discovery. So they're blaming all this, lateness in the discovery in part on former Special Prosecutor Mello being ill. But I mean, first of all, isn't all this stuff supposed to be in PDFs and electronic? And second of all, so that someone else would have it. But second of all, whatever happened to like having a courier? And the courts have their own, by the way. But,
Yeah.
Why couldn't somebody package all this stuff up in a big brown envelope, call FedEx, UPS, whoever? So I think that sounds like the dog ate the homework kind of an excuse to me.
Well, I mean, it does. But if Mello was sick, that arguably they have some kind of excuse. But I don't know. It's hard to tell whether that's a legitimate excuse because they had other ways of getting the information through the defense.
I'm just saying, I know there is illness. We've all had our little or big battles with health as one ages out. That happens, but there's such a long period of time went by, and constitutional requirements for making proper discovery and requiring the disclosure of all exculpatory information rise to the level of scratching our heads and figuring out how to deal with these things when they happen.
Yeah, that's true. So in sum, the defendant wishes to tell a jury that the Commonwealth engaged in a plot with Kate Peter and Keaney to make her a witness, then lure him to her apartment, provoke him to criminal conduct, then arrest him so his bail could be revoked. So cunning were the alleged plotters that Ms. Keaney studiously avoided any mention of their plot and its apparent progress when texting Tully. Nothing like "it worked" or "he's here now, arrest him." Oddly, neither Tully nor any other officer outside of Keaney's apartment, waiting to burst in and arrest Keaney at the appropriate moment, and not incidentally protect Keaney from any harm. Equally oddly, Keaney never reported the incident to the local police the following day, a lapse that prompted her alleged conspirator Tully to make the call.
There is an interesting piece of content that was done by Mike Radots, who I generally love his material. He has a lot of ability to do a good production value when he creates something. He did an episode on the Keaney incident, and I would highly recommend that everybody go and take a look at that because it explains the whole thing, which was just kind of glossed over here and makes one of many issues that arise in that incident. Cosgrove tries to, minimize the whole thing by just saying, "Oh, she didn't call the police the next morning." This motion goes on and on and on. Given as the defense says Peter's cooperation with the Commonwealth and her dislike of Keaney, it hardly seems probable that she sent links to evidence she thought fex culpatory. Okay, so all right, that's a typo. All right, everybody does it. We're not going to give him a hard time for that. The reasonable and probable inference is that she sent, because I first thought that's another one of those words that I had to look up, but there's no such word as fex culpatory. All right. The reasonable and probable inference is that she sent links to Keaney's own broadcast, which she thought to be inculpatory and pertinent to existing or possible charges against him. Thus, the defendant wisely makes no argument that the content of the missing links is exculpatory, but fiercely asserts that they demonstrate her bias against Keaney. The inference must then be that bias is demonstrated either by the content of the messages containing the links, but note that the defendant quotes none, or the mere fact that Peter was providing evidence to the Commonwealth, even if that evidence were probative of guilt. But there is nothing damning in any citizens assisting a police investigation by providing information. Rather, Ms. Peters' lack of credibility, if such there is only demonstrated by the defense's parade of her prior antagonistic statements against Keaney and what it terms her documented history of falsifying evidence against him. Yeah, remember that phony federal complaint that was cut and pasted together, where she got a complaint from another case and she cut and pasted Mr. Keaney's name on it to show that he was a bad guy and there was litigation involving him when it was a fake. Remember that?
I think, yeah, I remember. That was Peter. That was, Peters. Yeah,
right.
Katie Peters. Yeah, she's, yeah, I remember.
She's the former employee.
Yeah.
Okay. Okay. There's a lot to this, but, for time constraints, we don't read every word of it. I think we've hit some of the important stuff. Conclusion: for the reasons set forth by the Commonwealth, the defendant's motion to dismiss as apparently incorporated in the Betterow affidavit should be denied, with the exception of the defendant's prayer to disqualify Attorney Mello, which the court should take no action on as the issue is moot. Okay, what they're saying there, we glossed over that one. What they're saying there is Attorney Mello is ill. He will not be capable of really appearing in court. And so, the motion to get him out of the case it's just moot.
Yeah. There's one thing that I did want to mention. And
okay, please do.
In looking at Kearney's affidavit, looking at Betterow's affidavit.
Yeah.
He had mentioned things about Tully giving opinions in the grand jury, and apparently that's a no-no. I think Tully gave opinions on whether or not Kearney intended to intimidate, witnesses by his videos or something like that. I don't know if you remember that.
Yeah.
And that was not addressed in this motion. They mention it. The Cosgrove mentions it, but he doesn't elaborate further about he doesn't deny it, or I don't know.
So there were a lot of things in the mega motion, which we talked about before, and I'll link it down. I'll link our episode down below if people want to go back and look at that. I think Mr. Cosgrove just was so upset by the fact that the mega motion was brought and the affidavit was 87, 88 pages that he just felt the need to bring all this. All I can say is flowery verbiage, and his opposition was really it just meandered all over the place, kind of like I am right now. It wasn't the kind of thing where the motion itself, the mega motion, you could see the outline, point 1, point 2, 3A, B, C, 4. It was an outline that had been created, and then there was a discussion. It seems like the opposition was kind of thrown together at the last minute with some animus, some unhappiness, and it was just thrown together. And that's exemplified kind of by the fact that he filed it late, and then not only that, there was an attempt to not even ask for permission, but just say, "Hey guys, this is it." So let's take a look at the Commonwealth's motion to file it late. Here is the Commonwealth's motion for leave to file late, and 2, to impound the Commonwealth's appendix. So what is the old saying? It's always easier to ask for forgiveness than permission. So you and I were talking before we did this episode. The normal course of things is if you see you're going to miss a deadline and you have a good reason, a death in the family, God forbid, or an illness, that's good grounds. That's good grounds that almost every court in the world is going to say, okay. But what Attorney Cosgrove did here is he filed the motion and the response the same day. And he said, now comes the Commonwealth and moves this court for leave to file late its memorandum in opposition to Attorney Betterow's affidavit in support of motion and associated submissions. As reason, therefore, the undersigned counsel states that despite diligent attempts to complete the work by November 17th, additional time was reasonably required. Among the reasons for delay, undersigned counsel underestimated the necessary time for both these matters and another matter due the same day on a case before Judge Krupp, and also encountered delays in procuring requested affidavits. So he's saying, all right. And you know what? The court gave a marginal order, which you see written across the left-hand side there. And they just allowed it. That's it. The 26th of November. Allowed. Yeah. So there's really, that's just the way it was. And then, interestingly, the court had another response. Procedural order regarding 12-5-25. The court hereby orders the motion to dismiss hearing scheduled for December 5th of 2025 converted to a status hearing. So the big hearing that we were all expecting on the mega motion to dismiss filed back in September, that's not going to happen. Instead, on December 5th, 2025, on that date, counsel should be prepared to address the following issues: the status and potential impact of any motions currently under advisement. B, outstanding discovery and or discovery disputes. C, scheduling of in-person hearings on pending motions and or additional anticipated motions. D, potential joinder motions. E, potential trial dates. So what I'm taking from that, correct me if I'm wrong, is that they're not going to hear the motion to dismiss, but under C, remember at the very end of the what's been called the mega motion, Attorney Bedros says, it would be very helpful right now. I think his language was much more stronger than that, to have an evidentiary hearing on some of this. Remember that?
Yeah.
So I guess they're going to argue not the motion, but how the motion is going to be handled. That's how I read that. Yeah. I suspect, well, let me finish reading it. Such hearing will be held via Zoom to be administered by the session clerk in the Norfolk Superior Court. The parties are not to appear in person. The Zoom meeting will be open to the public promptly at 2:15 p.m. All who wish to attend are welcome to sign in at meeting ID. There's the number. Counsel are directed to contact the session clerk upon receipt of this order to discuss an orderly sign-in process for the parties. So I think, on the one hand, this could mean they're actually going to discuss whether or not to have an evidentiary hearing on the motion to dismiss. But I'm thinking that another reading is that, the court's saying, oh, you know what, Cosgrove is right. Forget about the motion. We're not going to allow it. There are issues of fact. We're going to try the case. So I don't know.
Well,
what do you think?
I mean, I think the judge has to include everything because, he wants to talk about everything. So, it does. I don't think it necessarily means that he's going to deny the motion to dismiss. I think it means that he needs more time to read and go through everything because Cosgrove filed his response late. And so he's just going to want to talk about all these issues and an evidentiary hearing for that motion.
Right. So one of two things could happen. One of three things could happen. The first one is that the judge will say, okay, we're going to have these evidentiary hearings or hearing that Attorney Bedros wants. That's one. Number two, there are people out there that say that, some of the Turtle Boy charges have been dismissed. Some are still pending, obviously. The court may just be looking for a reason to get rid of the whole ball of wax. And so that could happen. The third thing that could happen is, they'll just schedule a trial. Let's do it all at trial. Because some of the issues, it is true, require a determination of who is biased and who is, prejudiced. And those are trial issues generally. Witness credibility is always an issue at any trial with any witness. So I don't know. What options are there? Answer down below. What are the options? What's going to happen? Are these Turtle Boy, Aidan Keaney cases going to continue and continue and continue? They've been going on now for a couple of years. Or will the court just say, So I'm curious what people think about all this.
And I think it's going to be important because this involves social media and how, having a social media channel and talking about things could be considered witness intimidation. So, I mean, if that's what I think is really interesting about this case.
I think you're right. I think it has implications for social media. In the last couple of days over the holidays, it's funny, I've gotten into conversations with a couple of different people about how social media has changed the landscape of everything. Not only are people not watching network news, or they're watching network news in much smaller numbers, but it affects all aspects of life, not the least of which is the court system, where confidentiality and sometimes privacy are really very important concerns. And I don't know, my only other thought is, and we forgot to mention this in our other episode that we did this weekend. With the Karen Reed removal to federal court, and this ties into social media, there's not going to be any cameras in the courtroom. And so social media will be playing a bigger role. For right or wrong, some reporters can go into the courtroom and, then go outside. They're not supposed to do it in the courtroom, but they can go outside and post their reports. But other people are just going to be making it up. So social media has really edged itself into pretty much all aspect of life, not the least of which is, the litigation process.
Yeah, very much so.
So we have viewer comments, and okay, that's fine. Go ahead.
It's just Lisa. Thank you so much, Andrew and Yoli. Excellent interview with Howie. Really enjoyed it. I've read all of Howie's books about Bulger, and he's a great author. Great episode. Have a lovely Thanksgiving. Oh, that's nice.
Thank you, Lisa. Thank you. Number 4. This was funny. Sometimes our listeners make me laugh. John Harmon, D4Y. This is Massachusetts. The jury slip has 2 selections. 1, she's a witch, drown her. 2, she's a witch, burn her. All right, that's fine.
Scooter says, no cameras for Karen's case either unless they can get it remanded.
I think that's unfortunate. That the federal court, I'm not a judge, who am I to say, but I think it's really unfortunate that the federal courts don't allow cameras in the courtroom. I just think it's really unfortunate. Scott McGinnis, people just don't see the big picture. They don't understand the deep corruption of the political system in Massachusetts. They are just lost, if not within the web of who and why they are so connected. Common theme throughout the Karen Reed case.
This is from Brenna O'Brien. Excellent live show, Andrew. I know lives aren't your favorites, but you do an incredible job. Yoli is great, and Howie was an awesome guest. Thank you for everything and being one of my favorite, if not my favorite, law tube attorney. Oh.
Thank you, Brenna. Brenna's a regular, and I don't know. I really don't like doing lives. There's just too many things that can go wrong. But that particular one seemed to go okay. Howie was a great guest. I've listened to him for years, and I was very happy that he was able to give us as much time as he did. So I guess that's the other question for our commenters down below. I really don't like doing them.
Well, it's hard when you're trying to pull up documents in a live. Sometimes it doesn't always go well. But if you're just interviewing somebody, and you're not necessarily going over documents or anything like that. If you're just interviewing somebody, sometimes that can go well, but the technical problems are the issue. And there's too much going on, the comment section and.
Yeah, so I will ask our audience. I will ask our audience down below. Should we do more lives? Should we do one a week? Should we just do them occasionally? Should we never do them? So those are the options. Let us know what you would like us to do. And speaking of Karen Reed, we don't sell stuff. We don't, I don't accept sponsors. I've actually had people approach me. We want to advertise this on your channel. We want to advertise. No. There's already enough ads in the world. So we don't run ads. I don't ask you to buy neckties or coffee mugs or anything else. All we ask you to do is to subscribe. It's free. It's the little clicky down below. And we're going to ask some of the Karen Reed characters to tell us how easy and free it is.
Pay for a subscription?
I do not.
Ask it differently. I'm going to allow that.
Well, you know now because you follow. You pay for a subscription?
I do not.
Did you get one for free?
Yes. I was not paying to any social media.
All right, Mr. Brennan.
Sorry, I have just a few more questions.
It's denied.
I was not paying to any social media.
Okay.
Okay, my closing thought with respect to the Aidan Keaney cases is that it just keeps going on and on and on, and deadlines come and go, and hearings come and go, where really very little, if anything, is accomplished. And I'm just wondering how much longer we're going to go with this. This potentially could be an out for the court to just wash its hands of the whole matter. Some of the indictments have been thrown out. Here's an opportunity for the court to throw out some more of the whole case. I would say they should do it. What are your closing thoughts?
Well, my closing thoughts are kind of what I said earlier about social media and how the court's going to view social media, talking about things on a public platform about cases and witnesses and whether or not that is witness intimidation, depending on what is said. So that I'm kind of more interested in that aspect. And I mean, I don't have any interest in the like any, how do you say, any game in this?
Yeah, I'm the same.
You know what I mean?
Yeah.
Like, but I'm interested in that to see how it shakes out.
Yeah, I am too. And we will see. I hate it. When I used to be a reporter, we had people that constantly gave us advice and coaching. And one of the things when I was out in the field, standing in front of the State House or standing in front of City Hall or whatever, one of the things that one of the people that used to advise me always said, Andrew, I hate it when you say, we'll have to wait and see. Give them the points that have to be addressed. Tell us what the procedure ahead is. Tell us how the issues that you raised in your report could be resolved one way or the other. And so I was told never to say we're going to have to wait and see what happens. But you know what? In this case, we're going to have to wait and see what happens. I don't know how else to put it.
Yeah. I mean, I don't know. I mean, it's interesting. It's interesting.
Oh, what kind of an emoji, if people have been with us through this whole episode, what kind of an emoji should we have them give us?
A microphone or?
Microphone. All right. We did that last time, but that's a good one. A microphone or a TV. A microphone or a TV. And Yoli, thank you. Be well. Folks, remember, be nice down in the comment section. If somebody says something you don't agree with, don't call them a name. Start your own thread. Tell us why you're so smart. What have you read? What have you seen? What are the facts that you know that maybe we glazed over? What is the law that you think applies? Show us your thought process. Don't call people names. And as I always say, be nice. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.